I discovered the theft on a Tuesday morning in August when my irrigation system started sputtering like a dying engine. Standing in my backyard in Mesa Verde, Arizona, watching brown patches spread across what used to be a healthy vegetable garden, I knew something was seriously wrong with my well. My name is Xavier Kowalski, and I had moved to this 3-acre property specifically because it sat on top of a private aquifer that had been documented and surveyed when I purchased the land 2 years ago. The property was technically within the boundaries of Saguaro Heights, a sprawling HOA community, but my parcel predated the development by 30 years. My grandfather had owned this land since the 1970s, and when he passed, he left it to me with explicit documentation showing the aquifer beneath my property was privately owned and separate from any municipal water rights. The HOA had been built around my property in the early 2000s, and I had repeatedly refused to sell to the developers, despite their increasingly aggressive offers. I called my well technician, Marcus, who had installed my irrigation system. He showed up that afternoon with his equipment, a weathered man in his 60s who had been working on wells in Arizona for 40 years. He dropped a camera down my well shaft while I watched the monitor, and what we saw made my blood run cold. Someone had drilled a lateral shaft into my aquifer, tapping directly into my water supply about 80 feet down. That is professional work, Marcus said, pointing at the screen. See how clean that drilling is? That's not some amateur operation. Someone hired a real crew to do this, and they knew exactly where to drill. I felt my jaw clench. Can you trace where it is going? The angle suggests it is heading northeast toward the HOA development. I would bet my truck someone over there decided they wanted access to your water without paying for it or asking permission. I spent the next 3 days doing research and making calls. I contacted a hydrologist named Dr. Patricia Chen from Arizona State University, who specialized in groundwater rights. She came out to my property with ground-penetrating radar equipment and confirmed what Marcus suspected. The unauthorized tap was feeding directly into the HOA's irrigation system, specifically servicing the golf course and common areas that required massive amounts of water. This is absolutely illegal, Doctor. Illegal, Chen said, showing me the radar imaging. They have essentially committed water theft, which in Arizona is a serious crime. Your aquifer is documented as private property, and they had no right to access it without an easement or agreement. I contacted a water rights attorney named Robert Fernandez that same day. He reviewed my documentation, the surveys, and Dr. Chen's findings. When I walked into his office in Phoenix, he was already shaking his head. This is one of the most blatant cases of water theft I have seen in 20 years of practice, Robert said. The HOA has violated multiple state statutes, Arizona revised statutes. Title 45 is very clear about groundwater rights. This is your private aquifer, and they have no legal claim to it whatsoever. What are my options? I asked. First, we send them a cease and desist letter. We document everything. We give them exactly one opportunity to disconnect from your aquifer, pay restitution for the water they have stolen, and face the consequences. If they refuse, we file both civil and criminal complaints. The cease and desist letter went out that Friday. By Monday morning, I had a response, but not the kind I expected. Instead of a letter from the HOA's attorney, I got a visit from Brenda Morrison, the HOA president, along with 2 board members I recognized from neighborhood meetings I had been forced to attend, despite not being an HOA member. Brenda was exactly what you would expect from an HOA president in an affluent Arizona development. She was in her early 50s, with an aggressive blonde bob haircut and the kind of tennis outfit that screamed she had never actually played tennis in her life. She marched up to my front door with her clipboard clutched to her chest like a shield. "Xavier Kowalski?" she said when I opened the door, not waiting for confirmation. "I am Brenda Morrison, president of the Saguaro Heights HOA board. We need to discuss this absurd letter your attorney sent us." I leaned against my doorframe, not inviting them in. There is nothing absurd about it. You tapped into my private aquifer without permission. That is theft. Theft? Brenda's voice went up an octave. That water is a natural resource that belongs to the community. Your property sits within our development boundaries, which means you are subject to our rules and regulations. My property predates your development by 3 decades, I said calmly. I am not a member of your HOA. I never signed your covenants, and that aquifer is legally documented as my private property. You had no right to drill into it. One of the board members, a man named Gerald who always wore polo shirts with popped collars, stepped forward. Look, we can resolve this reasonably. We are prepared to offer you a monthly stipend for water usage. Say, $200 a month. I actually laughed. Do you have any idea how much water you have been stealing? My hydrologist estimates you have been pulling approximately 50,000 gallons per day for the past 8 months. That is over 12 million gallons. At commercial water rates in Arizona, that is worth roughly $40,000, and that is not even accounting for the damage to my aquifer or the criminal penalties for theft. Brenda's face flushed red. This is extortion. You are trying to extort money from a community organization. I am trying to stop you from stealing my water, I said. You have 72 hours to disconnect from my aquifer and arrange for restitution, or my attorney will file criminal complaints with the county and state. Have a nice day. I closed the door before she could respond. Through the window, I watched them stomp back to their golf cart, Brenda gesturing wildly while Gerald nodded along like a bobblehead. The 72 hours came and went with no response from the HOA. True to his word, Robert filed criminal complaints with Maricopa County and sent copies to the Arizona Department of Water Resources. He also filed a civil lawsuit seeking damages, legal fees, and an injunction requiring immediate disconnection. While the legal process ground forward, I made a decision. If the HOA would not disconnect from my aquifer, I would do it myself. I called Marcus back and explained what I wanted to do. You want to cap the aquifer? He asked. That is going to cut off their entire unauthorized tap. That is exactly what I want. They had their chance to do this the right way. Now, I am taking matters into my own hands. It is your property, your water, your right, Marcus said. I will get a crew together. We can do it this weekend. That Saturday morning, Marcus arrived with 3 workers and a drilling rig. The plan was straightforward but required precision. We would drill a new access shaft parallel to my existing well, intersect with the aquifer at a point before the unauthorized tap, and install a concrete cap that would effectively seal off that section of the aquifer. My existing well would continue to function normally, but the HOA's illegal connection would go completely dry. The work took all day Saturday and half of Sunday. Neighbors from the HOA development started gathering at the property line, watching with increasing concern as we worked. I saw Brenda arrive around noon on Sunday, her face turning an impressive shade of purple when she realized what we were doing. You cannot do this, she screamed from the property line. This is illegal. This is sabotage. I walked over to the fence, wiping sweat from my forehead. This is my property, my aquifer, and my legal right. You were given multiple opportunities to disconnect voluntarily. You chose not to. Now you are facing the consequences. Our golf course needs that water. Our common areas need that water. You are going to destroy property values for the entire community. Then I suggest you connect to municipal water like you should have done in the first place, I said, or drill your own well on your own property, but you are not stealing from me anymore. By Sunday evening, Marcus had completed the cap. We tested my well system, and everything functioned perfectly. The unauthorized tap, however, was now completely sealed off. Within hours, I started hearing reports from HOA residents that the irrigation system for the golf course and common areas had stopped working. Monday morning brought another visit from Brenda, but this time she had the HOA's attorney with her, a slick-looking man in his 40s named Christopher Harding. I'd been expecting this and had asked Robert to be present. We met in my driveway, the August sun already brutal at 9 in the morning. Mr. Kowalski, Christopher began, my client informs me that you have taken action to cut off a water supply that has been servicing the Saguaro Heights community for months. This is creating an emergency situation. Robert stepped forward before I could respond. Your client illegally drilled into my client's private aquifer without permission, without an easement, and without compensation. They were given multiple opportunities to cease their illegal activity and chose to continue. Mr. Kowalski has every legal right to protect his property and his water rights. We are prepared to seek an emergency injunction requiring restoration of water service while this matter is litigated, Christopher said. And we are prepared to present evidence of ongoing criminal water theft to the judge, Robert countered. I have documentation, hydrological reports, and expert testimony ready to go. Do you really want to walk into court and admit that your client has been stealing water? Christopher and Brenda exchanged glances. I could see the calculation happening behind Brenda's eyes. She was realizing, perhaps for the first time, that this was not going to be a simple matter of bullying a single property owner. What do you want? Brenda finally asked, her voice tight. Full restitution for water theft, calculated at commercial rates, Robert said. Payment for all hydrological assessments and repairs to the aquifer. Payment of all legal fees. A permanent easement preventing any future access to my client's water rights, and a public acknowledgement from the HOA that they committed water theft. That's absurd, Christopher said. The costs you were describing could run into 6 figures. Then you should have thought about that before you drilled illegally into private property, I said. This conversation is over, unless you are ready to discuss actual settlement terms. They left, and I heard nothing for 3 days. During that time, the HOA's golf course began showing signs of serious stress. The fairways turned brown, and the greens started dying. Common areas that had featured lush landscaping began wilting in the Arizona heat. I heard through the neighborhood grapevine that the HOA had tried to connect to municipal water on an emergency basis, but the costs were astronomical and the infrastructure was not in place to handle the volume they needed. On Thursday, I got a call from Robert. You're not going to believe this. The Arizona Department of Water Resources just informed me that they are launching a criminal investigation into the HOA. Apparently, this is not the first time Saguaro Heights has had water rights issues. They tried something similar with a property owner on the south side of the development 3 years ago. What happened in that case? I asked. The property owner did not have the resources to fight back and eventually sold to the HOA at a loss, but it established a pattern of behavior. The state is taking this very seriously. The following week brought even more developments. A county investigator came to my property to document the unauthorized tap. He was a methodical man named Dennis Shaw who had been investigating resource theft cases for 15 years. He spent an entire day photographing, measuring, and documenting everything. This is one of the cleaner cases I've worked, Dennis told me. Usually these things get muddy with conflicting surveys or easement claims. But your documentation is airtight. The aquifer is yours. The tap was unauthorized, and they have been stealing water for months. The district attorney is going to love this. What kind of penalties are we looking at? I asked. For the HOA as an entity? Potentially significant fines, restitution, and possible dissolution if the judge determines they are operating in bad faith. For the individual board members who authorize this, that depends on what we can prove about their knowledge and intent. But water theft in Arizona can carry criminal charges, especially when it involves this volume. 2 weeks later, I received notice that the HOA had filed for an emergency board meeting to discuss the water crisis. As a property owner within the development boundaries, even though I was not an HOA member, I had the right to attend. Robert advised me to go and observe, but to say nothing unless directly addressed. The meeting was held in the community center, a sprawling building that featured a catering kitchen, a ballroom, and multiple conference rooms. When I arrived, the parking lot was packed, and I could hear angry voices before I even entered the building. The main ballroom was filled with residents, easily over 200 people, and the energy was hostile. Brenda stood at the front of the room with the other board members, looking significantly less confident than she had at my door. The golf course superintendent was there, along with the landscape company representatives, and I spotted Christopher Harding sitting in the front row with a stack of documents. "This emergency meeting is called to order," Brenda said, banging a gavel. "We are here to discuss the water service interruption affecting our common areas and to update residents on our legal situation." A man in the third row stood up immediately. "I paid $750,000 for my house specifically because of the golf course and the landscaping. My property value is tanking because everything is dying. What are you doing about this?" We are pursuing all legal options, Brenda said, but her voice lacked conviction. The situation is complicated by a dispute with a neighboring property owner. You mean Xavier Kowalski? A woman called out. I recognized her as Sandra, someone I had met at a previous neighborhood meeting. I heard you were stealing water from his well and he cut you off. The room erupted in shocked murmurs. Brenda's face went red. That's an oversimplification of a complex property rights issue. Is it true? Another man demanded. Did you drill into someone else's well without permission? Brenda looked at Christopher, who stood reluctantly. The HOA believed it had the right to access groundwater resources within the development boundaries. It has since come to our attention that the specific aquifer in question may have been subject to private ownership claims that predated the development. May have been? I could not help myself. I stood up in the back of the room. There is no may have been about it. Your board authorized an illegal tap into my private aquifer, stole approximately 12 million gallons of water over 8 months, and refused to stop when I gave you the opportunity. I have documentation, hydrological reports, and a criminal investigation underway. The room went silent. Every head turned to look at me, then swiveled back to Brenda. Mr. Kowalski, Brenda said, her voice shaking with barely controlled rage, you were not recognized to speak. I am a property owner within your development boundaries, which gives me the right to attend and participate in meetings, I said. And these residents deserve to know the truth. Your board committed water theft, exposed the HOA to massive legal liability, and is now trying to avoid accountability. Get out, Brenda shrieked. Security, remove this man. 2 security guards in polo shirts started moving toward me, but Robert, who had been sitting quietly beside me, stood up. If you lay a hand on my client, that is assault and battery, and we will add it to the growing list of legal issues facing this HOA. Mr. Kowalski has every right to be here. The security guard stopped, looking uncertain. A woman near the front stood up. I want to hear what he has to say. If the board screwed up, we need to know about it. I second that, said another resident. Brenda looked around the room, realizing she had lost control of the meeting. Fine, Mr. Kowalski, please share your version of events. I spent the next 20 minutes laying out everything. The discovery of the tap, the hydrological report, the legal documentation, proving my ownership of the aquifer, the cease and desist letter, the refusal to cooperate, and my decision to cap the aquifer. I explained that I had been willing to negotiate reasonable terms, but that the HOA had chosen confrontation over cooperation at every step. When I finished, the room was in chaos. Residents were shouting questions at the board. Someone demanded to know who had authorized the drilling. Another wanted to know how much this was going to cost in legal fees and settlements. A third asked whether individual homeowners could be held liable for the board's decisions. Gerald, the board member who had offered me $200 a month, finally stood up. I wanted on the record that I voted against the aquifer tap. I told the board this was a bad idea, but I was outvoted. That's not true, Brenda shouted. You were at the meeting. You saw the engineering reports. Reports that failed to mention the property rights issues, Gerald shot back. Reports that you commissioned from a firm owned by your brother-in-law, I might add. That revelation caused another explosion of outrage. I watched as the meeting dissolved into accusations and counter-accusations. Board members were pointing fingers at each other. Residents were demanding resignations. Christopher Harding was frantically taking notes, probably calculating his billable hours. Robert leaned over to me. I think we should go. We have made our point. We slipped out of the community center while the chaos continued inside. In the parking lot, Robert turned to me with a grin. That went even better than I hoped. The HOA is imploding. By tomorrow morning, I bet we will have serious settlement offers on the table. He was right. The next morning, Christopher Harding called Robert with an offer. The HOA would pay $80,000 in restitution for the stolen water, cover all my legal fees and hydrological assessments, agree to a permanent easement preventing future access to my water rights, and issue a public apology. In exchange, I would agree not to pursue individual criminal charges against board members. What do you think? Robert asked me when he called to discuss the offer. What about the state investigation? I asked. Can we control that? No. The Arizona Department of Water Resources and the district attorney will pursue whatever charges they deem appropriate, regardless of our civil settlement. but this would resolve your personal claims. I thought about it for a moment. Counter with $110,000 for restitution, calculated at actual replacement cost for the volume of water stolen. And I want the apology published in the local paper, not just sent to residents. Also, Brenda Morrison needs to resign from the board as part of the settlement. Robert laughed. You drive a hard bargain. Let me see what I can do. The negotiations took another week, but ultimately, the HOA agreed to my terms. $110,000 in restitution, full payment of legal fees that ran to another $35,000, a public apology published in the Mesa Verde Register, and Brenda Morrison's resignation from the board. The permanent easement was documented and recorded with the county, ensuring no future HOA could attempt to access my aquifer. The apology appeared in the newspaper on a Friday morning. It was brief but satisfactory, acknowledging that the Saguaro Heights HOA had illegally accessed water resources belonging to Xavier Kowalski without permission or compensation, apologizing for the violation of property rights and committing to better oversight and legal compliance in the future. Brenda's resignation was announced the same day. I heard through the neighborhood grapevine that she was absolutely furious and had threatened to sue the HOA for wrongful termination. But Christopher Harding had apparently explained to her in very clear terms that her exposure to personal liability was significant and that resignation was her best option. The state investigation, however, was just getting started. Dennis Shaw called me in September to let me know that the district attorney had decided to file criminal charges, not against the individual board members, but against the HOA itself as a corporate entity. The charges included theft of water resources, illegal drilling operations, and fraudulent misrepresentation in their permit applications. Can you charge an HOA like you would charge a person? I asked. Arizona law allows for corporate criminal liability, Dennis explained. The HOA is a legal entity, and it can face criminal penalties just like a person. In this case, we are seeking significant fines, mandatory restitution beyond what you already received, and a probationary period during which the HOA's operations will be monitored by the court. The criminal case moved slowly through the system. In November, the HOA entered a plea agreement. They agreed to plead no contest to reduce charges in exchange for a fine of $75,000, an additional $50,000 in restitution to be paid to the Arizona Water Conservation Fund, and 3 years of probation, during which any major decisions regarding water usage or property modifications would require court approval. The golf course, meanwhile, had been connected to municipal water at enormous cost. I heard estimates ranging from $300,000 to $500,000 for the infrastructure work required. The HOA had been forced to take out a loan and levy a special assessment on all member properties to cover the costs. Each homeowner was hit with a $5,000 bill, which did not win the new board any popularity contests. The landscape in the common areas was simplified and converted to native desert plants that required minimal water. The golf course was maintained, but at significantly higher operating costs due to municipal water rates. Property values in Saguaro Heights did take a hit, dropping roughly 10% according to local real estate agents, though it was hard to separate the impact of the water crisis from broader market trends. For my part, I used the settlement money to make improvements to my property. I upgraded my irrigation system with modern efficiency features. I installed solar panels to offset my energy costs. I even added a small greenhouse where I could grow vegetables year-round without relying solely on outdoor gardening. In January of the following year, I was contacted by a journalist from the Arizona Republic who was writing a feature story about water rights disputes in the state. She interviewed me extensively, along with Dr. Chen, Robert Fernandez, and even Dennis Shaw. The article ran in February with the headline, "Property Owner Fights HOA Over Water Theft and Wins," and it sparked a larger conversation about HOA overreach and water resource management in Arizona's growing communities. I started getting calls from other property owners in similar situations. People who had been pressured by HOAs, who had faced questionable assessments or rules, who felt like they were fighting impossible battles against well-funded community organizations. I could not help them all, but I referred them to Robert and to other attorneys who specialized in property rights disputes. One case particularly caught my attention. A woman named Paula, who owned a 5-acre parcel in Scottsdale, was fighting her HOA over their attempt to force her to remove a historic barn that predated the development. The HOA claimed the barn violated their aesthetic guidelines. Paula argued, correctly, that her property had grandfathered rights. I introduced her to Robert, and he took her case. Last I heard, she won a settlement, and the barn was protected by a historic preservation designation. The new board at Saguaro Heights turned out to be significantly more reasonable than Brenda's administration. The new president, a retired engineer named Thomas, reached out to me in March to introduce himself and to assure me that the HOA had learned from its mistakes and would not be causing me any further trouble. "I want you to know that we have implemented new policies," Thomas told me over coffee at a local shop. "Any major decision now requires approval from an independent attorney. We have hired a professional management company to handle operations, and we've established a property rights committee to review any issues that might affect neighboring landowners." "I appreciate that," I said. "I never wanted to be at war with my neighbors. I just wanted to protect what was mine." "And you had every right to do so," Thomas said. "What the previous board did was unconscionable. They were so focused on keeping costs down and maintaining appearances that they lost sight of basic legal and ethical principles." We parted on good terms, and I genuinely hoped the HOA had turned a corner. Over the following months, I noticed positive changes in the community. The new board was more transparent, holding regular open meetings and publishing detailed financial reports. They settled several long-running disputes with other property owners, including a boundary issue that had been festering for 5 years. In May, I received an invitation to speak at a property rights conference in Phoenix. The event was organized by a coalition of landowners associations, and they wanted me to share my experience fighting the HOA water theft. I was nervous about public speaking, but Robert encouraged me to do it. "Your story matters," he said. "You stood up for your rights when a lot of people would have given in or given up. That needs to be heard." I accepted the invitation and spent 2 weeks preparing my presentation. On the day of the conference, I stood in front of about 200 people and told my story from beginning to end. I talked about discovering the theft, the legal process, the confrontation with Brenda, capping the aquifer, and the eventual settlement and criminal case. When I finished, the applause was thunderous. During the question and answer session, people wanted to know everything. How did I find the right attorney? What did the hydrological assessment cost? How did I handle the stress of the fight? What advice would I give someone in a similar situation? I answered as honestly as I could. Find experts you trust. Document everything. Know your rights and be willing to stand up for them. Do not let anyone bully you into giving up what is legally yours. And understand that sometimes the fight is worth it, not just for you, but for everyone who comes after you. After the conference, a man approached me. He introduced himself as Victor Kane, a state representative from Tucson. "I have been working on HOA reform legislation for 3 years," he said. "Your case is exactly the kind of example I need to show why these reforms are necessary. Would you be willing to testify before a legislative committee?" "What kind of reforms are you proposing?" I asked. "Stronger oversight of HOA boards, mandatory independent audits, clearer guidelines on property rights and grandfathered parcels, and criminal penalties for board members who knowingly violate the law. Right now, HOAs operate with very little accountability. That needs to change." I agreed to testify, and in July I found myself at the state capitol in Phoenix, sitting before a legislative committee and telling my story once again. This time, the audience included lawmakers, journalists, and representatives from HOA industry groups who were not happy about the proposed reforms. One of them, a lawyer representing the Arizona HOA Management Association, tried to paint my case as an outlier. This was a clear case of wrongdoing by a single HOA, he argued, but we should not use one bad example to create burdensome regulations that will affect thousands of well-run communities. Representative Kane was ready for that argument. "How many cases have to happen before we acknowledge there is a systemic problem? I have documentation of over 40 similar disputes in Arizona in the past 5 years alone. Property owners being bullied, rights being violated, and little to no accountability for the boards responsible. This is not one bad apple. This is a structural issue that needs addressing. The committee hearing lasted 4 hours. By the end, I was exhausted, but I felt like I had made a difference. The proposed legislation did not pass that session, but Representative Kane told me he was committed to bringing it back and refining it based on the testimony and feedback they had received. Meanwhile, life on my property settled into a comfortable rhythm. My irrigation system worked perfectly, fed by an aquifer that was now legally protected from any future encroachment. My garden flourished, producing more vegetables than I could eat. I started donating excess produce to a local food bank, which felt like a good way to give back to the community. In September, nearly a year after I had first discovered the water theft, I was working in my greenhouse when I heard a vehicle pull into my driveway. I walked around to the front of the house and found Thomas, the new HOA president, climbing out of his truck. "Xavier, I hope I am not interrupting," he said. "I wanted to talk to you about something." "Sure, what is on your mind?" "The board has been discussing ways to rebuild trust with the community, and we had an idea. We would like to create a community garden on one of our common area parcels, plots that residents could use to grow vegetables, teach kids about gardening, that sort of thing. We were hoping you might be willing to consult on the project. We would pay you, of course." I was surprised. "You want my help? You have turned your property into a model of sustainable desert gardening. Your irrigation efficiency is impressive, your crop yields are excellent, and you clearly know what you are doing. We figured if anyone could help us create something worthwhile, it would be you." I thought about it. Part of me was still wary of any involvement with the HOA, but Thomas seemed genuine, and the idea of a community garden was actually appealing. It was the kind of project that could bring people together and serve a real purpose. "Let me think about it," I said. "Can I come see the parcel you were considering?" "Absolutely. How about tomorrow morning?" The next day, Thomas showed me a 2-acre parcel on the north side of the development. It had good sun exposure, reasonable soil, and access to the municipal water line. I walked the property, taking mental notes about drainage, orientation, and possible layout. "This could work," I told Thomas. "You would need to amend the soil significantly, install proper irrigation with timers and drip lines, and build raised beds to make maintenance easier. But yeah, this could be a really nice community garden. Would you be willing to design it and oversee the installation? We can pay you a consulting fee of $5,000 plus expenses." I agreed, and over the next 2 months, I worked with a landscape contractor to transform that parcel into a functioning community garden. We built 30 raised beds in various sizes, installed an efficient irrigation system, added a tool shed and a shade structure, and created paths between the plots. In November, the HOA held a ribbon-cutting ceremony, and plots were assigned to residents by lottery. The garden was a hit. Families who had never gardened before were suddenly growing tomatoes and peppers and herbs. Kids were learning where food came from. Neighbors who had never spoken were chatting over the plot dividers, sharing tips and seeds and harvest stories. It felt like something genuinely positive had come out of all the conflict. In December, I got a call from Dennis Shaw, the county investigator. "I wanted to give you a heads up," he said. "Brenda Morrison has been charged with fraud and embezzlement related to her time on the HOA board." "What? That is separate from the water theft?" I asked. "Completely separate. During the water investigation, we uncovered irregularities in the HOA's financial records. It looks like Brenda was approving invoices from her brother-in-law's companies for work that was either never done or significantly overbilled. We are talking about potentially $200,000 over 3 years. "That is incredible," I said. "Does the HOA know?" "They have been notified. The new board is cooperating fully with the investigation. Brenda is looking at serious criminal charges this time." The case against Brenda moved forward through the winter. In February, she was indicted on 8 counts of fraud and embezzlement. The evidence was apparently overwhelming, including emails where she discussed the scheme with her brother-in-law and financial records showing the fraudulent payments. Her brother-in-law was indicted as well, facing charges of conspiracy and fraud. In March, facing the prospect of a trial and potentially significant prison time, Brenda took a plea deal. She pleaded guilty to 5 counts of felony fraud in exchange for the other charges being dropped and a sentencing recommendation of 5 years in prison with eligibility for parole after 2 years. She was also ordered to pay full restitution to the HOA, which would likely bankrupt her. The sentencing hearing was in April, and I attended as an observer. I sat in the back of the courtroom and watched as Brenda, looking significantly older and more haggard than the aggressive woman who had shown up at my door almost 2 years earlier, stood before the judge. Her attorney made an impassioned plea for leniency, talking about her years of community service and her lack of a prior criminal record. The prosecutor countered with the severity and duration of the fraud, the betrayal of trust, and the significant financial harm to the HOA and its members. The judge was not sympathetic. "Mrs. Morrison, you held a position of trust and responsibility, and you abused that position systematically over an extended period. You stole from your neighbors and your community. The harm you caused goes beyond the financial. You damaged people's faith in the institutions that are supposed to protect them. I see no reason to deviate from the sentencing recommendation." Brenda was sentenced to 5 years in state prison. Her brother-in-law took a plea deal shortly afterward, receiving 3 years in prison for his role in the scheme. The HOA filed civil suits against both of them to recover the stolen money, though it was unclear how much they would actually be able to collect. As spring turned to summer, life continued to move forward. The community garden flourished, with residents harvesting impressive amounts of produce. The HOA settled into a routine of competent, transparent management. Property values in Saguaro Heights stabilized and began recovering. My own property continued to thrive, fed by an aquifer that was now indisputably and permanently protected. In June, Representative Kane called to tell me that a revised version of his HOA reform legislation was going to be introduced in the next legislative session. "We have incorporated feedback from the previous hearing and built in some compromises to address industry concerns while still protecting property owners," he explained. "I am optimistic about our chances this time." "What can I do to help?" I asked. "Just be ready to testify again if we need you. Your story is powerful, and having a real person behind the statistics makes all the difference." I thought about everything that had happened since that Tuesday morning when I discovered my irrigation system sputtering and failing. The anger and frustration of discovering the theft, the stress of the legal battle, the satisfaction of winning, the unexpected opportunities that had come from standing up for my rights, the community garden that had grown from the ashes of conflict. It had been exhausting and expensive and at times overwhelming, but I would do it all again in a heartbeat, because property rights matter, because theft is theft regardless of who commits it, and because sometimes when you stand up to bullies, you not only protect yourself, but create opportunities for others to stand up as well. My phone rang, interrupting my thoughts. It was Robert Fernandez. "Xavier, I have interesting news. Remember Paula, the woman with the historic barn in Scottsdale?" "Of course." "She won her case, complete victory. The court ruled that the HOA had no authority to force removal of a structure that predated the development and had historic significance. But here's the interesting part. The judge cited your case extensively in his ruling. He talked about HOAs overstepping their authority and the importance of protecting property rights that existed before the association was formed. Your case is creating precedent that is helping other people win their fights." I felt a surge of satisfaction. "That is good to hear. Really good. You did something important, Xavier. You stood your ground when it would have been easier to cave. That matters more than you probably realize." After we hung up, I walked out to my back porch and looked across my property. The irrigation system was running, fed by my aquifer, watering the garden that fed me and the food bank and anyone who stopped by when I had excess produce to share. In the distance, I could see the edge of the Saguaro Heights development, where a community garden now occupied a space that represented reconciliation and moving forward. The sun was setting over the Arizona desert, painting the sky in shades of orange and purple and red. It was beautiful and harsh and unforgiving, much like the fight I had been through. But I was still here, still standing, still growing things in this challenging soil. My aquifer was mine, protected by law and by precedent, and by the simple fact that I'd been willing to defend what was mine. The HOA had learned an expensive lesson about respecting property rights and operating within the law. Brenda Morrison was in prison, paying the price for her crimes, And somewhere in the state capitol, Representative Kane was working on legislation that might prevent other property owners from having to go through what I went through. I thought about all the people I had met along the way. Marcus, the well technician who had first identified the theft, Dr. Chen, whose expertise had documented the crime, Robert Fernandez, who had fought for my rights with skill and determination, Dennis Shaw, who had investigated thoroughly and professionally, Thomas, who had helped the HOA rebuild into something better, Representative Kane, who was fighting for systemic change, Paula and the other property owners who were winning their own battles, in part because I had won mine. None of us fights alone, even when it feels like we do. Every stand we take, every right we defend, every principle we refuse to compromise creates ripples that spread outward in ways we may never fully see or understand. My fight over a stolen aquifer had become part of something larger, a growing movement of property owners refusing to be bullied or intimidated by organizations that had forgotten they were supposed to serve their members, not rule over them. I walked back inside as the last light faded from the sky, feeling tired but content. Tomorrow I would work in the garden. Tomorrow I would check on the community garden and answer questions from residents who were still learning. Tomorrow I would continue living my life on my land, drawing water from my aquifer, growing food in the desert, and standing as a quiet reminder that property rights matter and that sometimes the only way to protect what is yours is to fight for it. The HOA had tapped my aquifer without permission for their lawns. I had capped it, and their system had gone dry. In the end, that simple act of defending my rights had triggered consequences far beyond anything I could have imagined. Settlements, criminal charges, prison time, legislative reform, community reconciliation, and precedents that would protect other property owners for years to come. It was not the fight I had wanted, but it was the fight I had won. And that, I thought as I turned off the lights and headed to bed, was enough.